Hello, and welcome to Module 6, the final module for the training for high-fidelity wraparound providers working in Wyoming's juvenile courts. This module will be focused on the topic of confidentiality. The juvenile court process is confidential by statute. These statutes provide very clear and strict limits on the release of juvenile court and agency files. Wyoming Statute 14.3.214 applies to MDTs and states all records concerning reports and investigations of child abuse or neglect are confidential except as provided by Wyoming Statute 14.3.201 through 215. Any person who violates this subsection is guilty of a misdemeanor and upon conviction shall be fined no more than $500 or imprisoned in jail for no longer than 6 months or both. We want to make sure that high-fidelity wraparound providers understand the significance and severity of confidentiality in juvenile court. Due to the confidential nature, the public is generally excluded from juvenile court cases, and juvenile court proceedings are closed proceedings pursuant to Wyoming Rules 2B and C. Generally, the public is excluded, but foster parents are allowed, but the court can allow certain individuals with an interest in the hearing. The court can also exclude foster parents if it's in the best interest of the child or necessary to protect privacy. High-fidelity wraparound and care management entity staff and providers cannot attend court proceedings or MDTs unless they are subpoenaed to court or ordered as a member of the MDT by the judge. It is a safety concern if the child's best interest that the privileged information is shared with the DFS worker or team, then a GAL or attorney has to make an attempt to get permission from the client to share the information, or try to get the information from another source instead of revealing that the confidential information that the client shared. Everything that the client shares with the attorney or GAL when meeting one-on-one is considered confidential and privileged. Then, if it needs to be shared, the attorney can explore the normal exceptions to confidentiality. Child clients should be treated as adult clients whenever possible. If a GAL and a child do not agree on the best course of action for the case and the child, the GAL must inform the court of its determination of the child's best interests and what the child believes is in his or her best interest. Parents may be able, just the fact that a child is involved in a juvenile court proceeding is confidential. It's a misdemeanor crime to keep records from reports and investigations and not keep them confidential. However, this does not apply to sharing information about the child's current care, medical needs, visitation, etc. with DFS caseworkers and the GAL. When in doubt, foster and relative caregivers should ask before releasing or sharing. Parents may be able to sign a multi-party release to allow information to be shared with the MDT. It's imperative for foster and relative caregivers to understand the importance of confidentiality within juvenile court. Both court rules and state and federal statutes set forth confidentiality laws that protect the children and families in juvenile court. If the foster or relative caregiver has questions about confidentiality, they should ask the DFS caseworker or another team member before releasing or sharing any information. This includes information shared with a high-fidelity wraparound provider. The juvenile court process is confidential, including the MDTs. However, the statutes do allow for the sharing of relevant information among MDT members to make case planning recommendations for the court. If an MDT member or other non-member with relevant information declines to share information that's relevant due to confidentiality concerns, and the MDT feels the information is necessary, the first step should be to obtain a release of information from the parties. If the parties refuse to sign a release, the court should be notified and the need and relevance of the information, and a court order for release can be obtained when appropriate and necessary. It's also important that you know that the MDT statutes set forth clear restrictions on the release of any information obtained through the MDT process. This information is confidential and cannot be used by anyone outside of the MDT process or for purposes unrelated to the MDT's function and authority. Confidential information can only be used for purposes relating to making recommendations for appropriate family service planning and sanctioning of a child or family. This generally includes information relevant to the treatment needs, as well as information relevant to determining the child's placement, education needs, and service needs. Members of the team may not use or share the information outside of the MDT unless there is separate authority for gaining access and using the information. Parents may be able to sign a multi-party release of information in order to make information available to the MDT. Separate releases may be necessary for mental health information, and a separate release is required to access information regarding substance abuse. Such releases must specifically state what information and records are requested. Entities holding information may have a specific release form that such entity requires to be signed in order to release that information, and further social workers and probation officers may provide release documents for parental signature. If an entity chooses not to release requested records, the MDT should notify the court. All ordered members and invited attendees of the MDT should sign documents stating that they understand and agree to abide by the statutes governing confidentiality of the MDT. The MDT coordinator should maintain the original confidentiality agreements, and the social worker probation officer should maintain a photocopy. Depending on the preference of the MDT, a confidentiality agreement could be signed by each appointed member and invited attendee at the beginning of the case, or a confidentiality agreement could be circulated at every MDT meeting to be assigned by all attendees. Some final tips for high-fidelity wraparound providers when navigating juvenile court and the confidentiality proceedings. First, don't ever share the fact that a child is involved in the juvenile court process. Just this, in and of itself, is confidential and goes against Wyoming statute. You are not able to attend hearings unless you're ordered by the court or subpoenaed to provide testimony. If you are appointed to the MDT, the information that you learn at that MDT cannot be shared with non-MDT members. High-fidelity wraparound providers appointed to an MDT may need to share non-negotiable items learned at the MDT with the wraparound team, but should talk to the attorneys first and find a way to do this and not break confidentiality. If ever in doubt, check with the DFS caseworker or the child's attorney or GAL before releasing or sharing any information. Thank you. This is the end of Module 6 and the final module in this training. We appreciate you attending.